The next area we're going to discuss is called preparation for mediation. At mediation, you make an offer to the other side and hope that they'll accept it. They also make an offer to you called a counteroffer and hope that you're going to accept it. In order to start that process, you're going to need 4 different items to go into mediation and have them completed. Number 1 is going to be a completed, signed, and verified parenting plan. What we do at mediation is going to be taking this parenting plan to the other side and ask them whether they agree to you having shared parental responsibility, if they agree to the time sharing, if they agree to the exchanges, or if they agree to the communication. So by having a completed parenting plan, you can provide that to the other side and get them to either agree or disagree to what you're offering. If they don't agree to it, they can tell you at the mediation what sections they don't agree to, and then you can go back and forth, whether you can do a counteroffer, another counteroffer, and try to finalize your parenting plan. That's why it's important that you complete your parenting plan prior to mediation. Number 2 is going to be your equitable distribution worksheet. What this is basically an ED worksheet of all of your assets and all of your liabilities. You initially receive this as part of your packet. However, we put it into a worksheet type of format and again provide this to the other party at mediation. We offer our ED worksheet and say, hey, do you agree or disagree with these numbers? Or do you agree to the distribution of a particular asset or a liability? Again, it's a good starting point to try to get the other side to either make a counteroffer or come up with some type of resolution on your case. Number 3 is going to be the child support guideline worksheet. We use this based on the number of overnights that you provided in your parenting plan, as well as your financial affidavit showing the incomes of the parties. What we do at mediation is provide the child support guideline worksheet to the other side and ask them whether they agree to the incomes of the parties, the health premiums associated with the parties and the minor child, the number of overnights, and ultimately the child support obligation per month for one of the parties. Again, we can use this at mediation to see whether they're going to agree or make a counteroffer regarding child support. Number 4 is going to be your cash flow analysis. We use this in order to determine what your monthly need is for alimony purposes or what your ability to pay is regarding a claim for alimony or support. In the gray area here on your cash flow analysis, it will typically have different percentages regarding the payor and the payee, or the obligor and the obligee. What you typically want to do is try to get to 50-50 as possible or close as possible as you can. Sometimes there will be a situation where the payor is paying 53 or 55% of their disposable income, and that is going above usually what it is accepted as far as the courts in Hillsborough County. When we do a cash flow analysis, we want to try to make it as fair and reasonable as possible. Again, at mediation, you offer that to the other side and see if they'll agree or disagree or make some type of counteroffer regarding your request for alimony or given your ability to pay. These are all things that we do in preparation for your mediation. Also, as part of the mediation process, we typically might like to meet with the client in order to prepare either option A, option B, or option C prior to mediation. We want to have a sit down with you and discuss which options you want to provide and which backup options you want to provide as far as offers and counteroffers. If you go into mediation and you make an offer that you know the other side's not going to agree to and they're going to reject it, well, they're going to come back with a counteroffer. And if your option B is in the range of the counteroffer, that concludes your mediation process. However, if you have an option B or C, which is going to be your bottom line offer, I will know that going into mediation. That way we can discuss negotiations and settlement and resolve your case at mediation. So it's important to have at least 3 different options going into mediation to know where you stand in regard to all matters. Also be ready to discuss at mediation partial settlement agreements. What I mean by this, if you know the case is not going to resolve entirely at mediation, you can do a partial settlement. What you can do with that, for instance, if there's a big financial issue that's at stake, whether it's the valuation of marital assets, whether it's the income or imputation of income for the other side, you can agree to appoint a joint expert to do the valuation of the assets, to impute income to the other side, to do an analysis to determine if there is incomes that's being hidden or assets that are being hidden offshore, or if there's accounts that have not been provided. So at mediation, you can get the other side to agree to a partial joint expert stipulation. That way you can start the process of doing the financial analysis. You can also agree to appoint, for instance, a parent coordinator to help with the parties establish a parenting plan if it's a high conflict case, or if the parties do not co-parent. A parent coordinator can help the parties come to some type of parenting plan and ultimately time-sharing schedule. Or you can agree to a parenting plan evaluator. This would apply in a situation where the spouse on the other side is asking for the majority time and you're asking for the majority time and you can't resolve it at mediation. You can ask the court to appoint, or by stipulation, a parenting plan evaluator, and then have that person, who's typically a child psychologist, make a recommendation to the court and to the parties as to what's in the children's best interest. They usually will produce a report and give the recommendation. That's something you can do at mediation as well. Or if it's a situation where you're in dire need of some type of temporary child support or alimony, you can agree to some type of partial mediation agreement regarding child support and alimony. Also, you can agree to temporary attorney's fees at mediation as part of your analysis in trying to determine the other spouse's income, or to fight a custody issue, or get temporary support. You can get the other side to agree to temporary attorney's fees as well. Be prepared on all these issues at mediation, and you'll be a lot more efficient.